You're listening to the Immigration Lawyers Toolbox Podcast, the podcast that keeps your practice sharp and your clients happy. I'm your host, immigration lawyer John Khosravi, and every week we're bringing you insights, tips, and real-world conversations with top immigration attorneys and industry leaders. Whether you're here to grow your practice, stay on top of the latest trends, or get inspired, you're in the right place. Ready? Let's go. Hello, fellow Toolboxers. Welcome to episode number 422 of the Immigration Lawyers Toolbox Podcast. We're doing a great interview, round two, with Rita Sostrin, one of the top immigration attorneys in the business immigration space. And we're talking about H-1B and the craziness that we're going through, O-1s, and the future of immigration law practice for those who are heavy deep into it. How's it going to look with AI and pricing and client management and the like? And we go into detail on that. So it's very informative, to say the least. I recommend listening to the whole thing and really take some stuff away from it. And also just email me, letting me know, or comment wherever you're watching this, what your thoughts are about these issues that we talked about, not just again with H-1B, but also the future of immigration practice, helping people be able to manage their firms. And that's a big focus of what we're doing here, is how to make you become a better immigration attorney and law firm owner for those who own a law firm, but those who internally are helping manage, do stuff. There's always takeaways to make the experience of being an immigration attorney more profitable and just easier and more palatable when there's hard times. And one thing that one of our sponsors, our main sponsor, Immigration by Sunday, is doing is helping you do just that. They just take a deep breath. And that's what I should do right now. I'm about to do an ad run and I lost my place. So I'll take a deep breath. If you feel like you're running on fumes right now, you're not alone. Stress is practically baked into immigration law. But that doesn't mean we can't get better at handling it. Stress is not best. It's horrible. I mean, stress is kind of good. They say it's needed for you to be heightened senses, but consistent stress on an ongoing basis, which we're going through, and that's not good. On September 30th, the Immigration is hosting a free webinar just for immigration professionals. You'll walk away with 4 research-backed tools to build confidence and manage overwhelm at your work from a performance psychology pro, Nicolo Milankovic. Do yourself a favor and head to get.immigration.com/events to save your seat. That's get.immigration.com/events to save your seat. I'm going to be there. I think it's this coming Tuesday. So definitely check it out and be there. And thank Immigration by CRNA, not for that, but not just for that, but for supporting this podcast and also the Immigration Lawyers Toolbox magazine. Issue number 10 is out. We're interviewing the authors and getting the information out, but a lot of real good content there. As always, really appreciative of all the authors that support us and the sponsor. Check out the magazine. Go to iltbox.com or immigrationlawyerstoolbox.com. Click on the magazine link. Issue number 10 is there, along with back issues that you can check out to better your practice and better what you're doing. And before starting, I want to mention that the Immigration Lawyers Toolbox private community page, Circle.so, we always talk about nearing 400 members. Join now. A lot of intimate, private kind of conversations, information coming out, access to videos, CLEs, training, plus our courses. The premium courses are hosted there. Marriage immigration, how to run your own marriage immigration practice, EB1A. We got this great review I talked about last time from one of our members. Said, "Hey, John, I hope all is well. Just finished the EB1A course. I'm very pleased. Love that you avoided the lecture form and made the whole course a very hands-on experience. Thanks so much for putting it together." I was very, very happy. I'm going to be reading that constantly because I'm really excited about getting such a wonderful review from a colleague, immigration practitioner. There's the O1s. There's EB1A as an E2 investor. So the more, demand there is, we'll do stuff. I'm carving out a concept processing piece that's going to be there because a lot of people are interested in that because they don't do as much concept processing and you need to get the hang of it. But having said all that, none of the information provided here is intended as individual legal advice. Please consult with an attorney, but y'all know that already. Let's get the show started. Hi, Rita. Thank you for coming on the show again.
My pleasure, of course.
Wonderful. So let's the first things on everyone's mind is the H-1B situation. It's September 25th, a week after the proclamation. How has your weekend and week since been since that with your clients?
Well, it's been a little bit hectic. So as with the prior Trump administration, we're sort of now used to getting big news on Friday afternoons. I happen to be at a winery in Central California with a bunch of immigration lawyers. So it's, it was an interesting way to start the weekend. But on a more serious note, it really did create a lot of anxiety and kind of chaos and fear over the weekend with clients and individual clients, corporate clients emailing, panicking whether they can board the plane. I had people get off the plane over the weekend because we just didn't know if this proclamation applied to everybody who holds an H-1B visa or what the details are. So I still feel like we don't know exactly all the details, but what we now understand, or we think we understand, is that first of all, it's an entry ban. It's not a petition, H-1B petition ban. So we're continuing to file H-1B petitions. And the entry ban, according to various government sources, and some of them have really come out as, on Twitter or X,
Yeah.
as it's called now, or through other social media, they're saying it does not apply, the entry ban does not apply to current H-1B holders. And in fact, we have had clients who have received H-1B visa foils at consulates around the world at this point, and clients who have returned to the United States on valid H-1B visas. So the way that I understand it, it will apply to anybody who applies for a new H-1B petition. Maybe they're changing status from F1 or J1 or some other status to H-1B. I think it was really intended to apply to the future lottery cases, but there are also a lot of H-1Bs that are not subject to the lottery.
Yeah.
And it will apply to those who are either abroad or will leave the US and will not be able to come back to the US without the $100,000 fee.
So, I mean, there's a scenario where someone does change a status and they're here, but then eventually, if they leave, they'll have to pay to get back in for some like future filings. One problem that popped up is, what if you do change of employer and then is that a new application, or is it new compared to taking a cap position, or just any new one, even if you're like you took the cap number out, like you could have changed anyways?
So we don't know. That's a very good
Yeah.
question that you're asking. The way that I think it is intended to be, I think something like that, a change of employer should not be a new H-1B. This person has held an H-1B before. And of course, questions that are coming up, because on the form, on the I-129 form, when we fill out the form to apply for an H-1B, you could potentially, even for change of employer, it's not wrong to choose new employment as the box that you could check. You could also check the change of employer, change of employer.
Yeah.
So the petition would be approved either way. So if you checked the box new employment, which is not incorrect, kind of in the general context, does that mean that they will be subjected to
Yeah.
the $100,000 fee? Versus if you check the box that's right below that says change of employer, I don't know the answer to that.
Yeah, it's a messy one, and this goes along with the whole situation where the grace period is not covering you potentially in getting NTA'd if you're changing employers. So it makes it. It just shows immigration law. It's so complicated. Think like people think the public, oh, immigration will just put this rule. It's like no, it's so many variations of things that get hit, and then I mean, it's go without saying, like there's billions of dollars in company profits and management and HR stuff that gets hit on a whim, like on a decision like this. So it's just so ignorant to like think, even if you're anti-immigration, there's a way to do stuff. If you want to do it, just like plan it out. There's don't just come on a Friday night and say stuff. And half the stuff they were saying was wrong. The funniest for me was CBP's text for this is posted on Twitter, on X, and that's what's being referenced by the government to go to a Twitter page. And then they're like, don't listen to anyone else, bad info. But like, what do you mean? Like the Secretary of Commerce and the President are saying like it's $100,000 every year and this and that. So it's just so foolish, really. It's cartoonish at the lightest. What's happening?
Same with what is it? The Rapid Response, which is the White House's social media page. They're also posting it on X, and the press secretary from the White House. They're continuously posting explanations. It's all on social media now, so
Yeah.
now that's how we get the law.
Yeah, at least have it on the government page or something so we can rely on it. Because if social media, when the press secretary says it, it's still like we can't rely on that. It's a secretary put a secretary. If it was DOS, maybe we could do it, but it's a weird situation. Do you guys have? We only have like a couple H-1Bs at our firm, and so it wasn't that crazy. I had a couple of consultations on H-1B for people, for example, who their I-94 expired with their passport and they didn't notice it. And so then they just noticed it like on Friday and they called me up like, what's going on? I'm like, well, you could do nunc pro tunc or you just leave and come back in. But then this happened. So Saturday I was like, I had to message him like, listen, don't do anything. Wait till Monday to see what's going on. Don't like, because no one's going to know. And your employer's H-1B lawyer is going to be so busy that they won't have time to get to this right now. So expect delays and a couple of unlawful President's Day accumulations. They still have enough time for it. But That's makes it so hard for people. I feel so bad.
Yes, yes. So there's a lot going on. I also, I think you know that I handle a lot of physician cases, and in situations where a physician who's on a J-1 visa transitioning to an H-1B through a J-1 waiver of the 2-year home residence requirement. And I do have a couple of those situations now that I'm handling where the J-1 waiver, there's just not enough time to change from, because the waiver takes so long
Hmm.
from to change directly from J-1 to H-1B. These physicians have to wait in their home country until the J-1 waiver is approved, H-1B is granted. Well, this would be an example of a new H-1B that's subject to this $100,000
Yeah.
fee. So these hospitals, some of them are private clinics in medically underserved areas, or maybe academic institutions that are hiring these physicians, again, to work in medically underserved areas, are going to have to deal with this and either pay or miss out on these physicians, or try to apply for a waiver of a national interest exception,
Yeah. Now
which
there
we
was,
don't know what the parameters are for that.
which yeah, last time for the general trial ban, it's like a non-existent thing they just throw in there to satisfy the courts, I guess. But there was floated around this idea that they'll make an exception for doctors, but it's just like in news reports, nothing that's reliable.
Correct. Yes, I did see that in Bloomberg, but that's all we've seen so far. So we don't know if cap exempt institutions such as universities, medical centers, those other cap exempt will be not subject to the proclamation. Physicians in underserved areas, or just generally physicians or researchers, to yet to be seen.
So if you're at a weekend with immigration lawyers, that could, I mean, it's fun because it's stuff we think about all day, but it's not fun at all because this takes away from enjoying your time there and the unknowns. Was it just chaos between everybody, just shock and phone calls and text messaging the whole weekend?
Yeah, a lot of emails and calls, and I mean, hundreds of emails that we've been fielding since last Friday. Right now, I feel like the traffic has subsided in terms of emails. We've pushed out some announcements on our website and news lists, but yeah, but really, what we just don't know exactly what it's
Yeah.
going to be. And in fact, if somebody wants to pay the $100,000 fee right now, I don't know that there are a lot of people like that. They can't. There's no mechanism to
Yeah.
do it. They can't do it.
Yeah, people are shut out, so they can't even. This is so it's not thought out as well. There's the idea of it's like, are they trying to create chaos or is it incompetence? I kind of think they just like whatever, let's create the chaos. And the courts at halftime letting them get away with it, so they're like, why not? Hurt people we don't like. It seems.
Yeah, I think it is to create chaos and create this kind of uncertainty. And what we're seeing already is that a lot of private employers that would likely be subject to this, who are higher cap subject H-1Bs, initially they usually hire them on F1 OPT, practical training, because they get that for a couple of years, especially in STEM occupations, and then transition to cap H-1Bs. A lot of these employers just are not interested in hiring these kids fresh out of college or master's
Yeah.
programs with their OPT, even though they have work authorization, because they know they're not going to be paying the
Yeah.
$100,000 fee for the H-1B.
Yeah.
So it's already chilling kind of the effect of hiring foreign nationals.
Yeah. A lot of these larger companies are going to create brand subsidiaries or transfer to non-U.S. locations to have them work there instead. So U.S. is missing out on the talent and the income tax, all that kind of stuff that comes with it. But that's
Yep, I agree
policy for its.
completely.
Or,
That's it's going to drive uh, these companies to do something like that. Yes.
well, the alternative that people are going to go more now is the O visa, which has been growing, and not everyone could join, but to do it. But your office does O's. That's particularly in the entertainment space. But like, what are your thoughts on what's situated with O's right now? Have you been seeing stricter adjudications for those?
Uh, so yes, and I think that's just kind of the general Trump administration
Hmm.
attitude, stricter adjudication of everything. But we do handle a high volume of O-1s, both in arts and entertainment, and also science, medicine, academia. What I am seeing, and it's only been a few days, just this week, is in light of the proclamation for individuals who are abroad. A lot of my university clients and hospital clients are now considering doing O-1s instead of H-1Bs again, just because of the proclamation. Generally, of course, when, before this, all else being equal, when we have a choice between an H-1B and an O-1, of course, it's an H-1B. It's a lot easier. It's faster if it's not subject to the H-1B count. But here we are looking at O-1 visas starting to a lot more because of the news. But in terms of O-1s in the arts and entertainment space, a lot of those occupations were never H-1B occupations, because H-1B is a specialty occupation. You have to have a certain degree and a specialized job. And arts and entertainment world, those are not usually those types of jobs. And it's also not the type of employment that lends itself to H-1B sponsorship. So we handle those kind of cases with not employer-employee sponsorship scenario, but agency sponsorship. So that's kind of a whole other type of case preparation.
Hey, everybody, I'm going to jump in really quick to remind you of our marriage immigration course that's out. If you want to be a marriage immigration attorney, start your own law firm. We have the A to Z, from contracts to statutes and memos you got to know, which forms, admissibility things you got to be mindful for, how to talk with people during the consultation, I-751 and 400, what that's all about, how to prep it, and much, much more, office hours included. So just email me, info@immigrationlawyerstoolbox.com, or go to our website, and on the course page, we'll have a breakdown of how the course looks like there, immigrationlawyerstoolbox.com. Check courses, and you'll see B1A and E2 as well. But the marriage green card course is the creme de la creme. I think it's going to make a difference in your life. So with that, let's get back to the show. Now, what issues do you see with when you have like a agency do it? There's a dual representation of sorts on there. How often do you do it where the agency is just a nominal agent or something for the purpose of the O-1, which is legal? A lot of people do it. What is the situation? Because sometimes there'll be an artist who comes and they might have their own manager be in. So how do you deal with those kind of situations to inform and just explain why you need that?
Yeah, so agency sponsorship is actually a really great tool for O-1 visas. It's not available to a lot of other visas, but it is available in the O-1 context, also P1s. And it doesn't have to be for arts and entertainment only. Agency sponsorship is available to individuals who are traditionally self-employed. That's by regulation. And especially in today's world, in the last, 20 years, lots of us are traditionally self-employed. It could really be any occupation, including researchers, startup company entrepreneurs. So we do this agency sponsorship for in those scenarios, and it's basically for O-1 visa holders who don't want to be tied to a specific employer. Now, an agent, and we all kind of have a preconceived notion of what an agent is. It doesn't have to be a talent agency like actors use or people in the entertainment industry. It could be any entity with a legal agency relationship, and legal agency relationship means that they are available to accept service of process and various other things. But it's pretty easy to set up a legal relationship as an agent. Mm-hmm. Of course, the individual being sponsored for an O-1 visa, what the agent has to have kind of I usually recommend to clients, you need to pick, it has to be a U.S. entity. It could even be an individual, a U.S. citizen, a person, and you have to have a long-term professional relationship with the agent, because just like with an employer-sponsored petition, if an agent sponsor decides to terminate the relationship, that terminates the visa. So the visa is over at that point. So, but normally we represent also like proper big agencies here in Hollywood that sponsor their clients, but it doesn't have to be like that. It does need to be a legitimate sponsorship relationship, though. In those situations, and sorry, were you gonna ask?
No, I was gonna ask about the itineraries, but please go ahead.
Yes. So in those situations where we have those agency sponsors, the agent sponsor can also be the employer or of the individual, but they don't have to be. They could just serve the function of the agent. But to qualify for an O-1 visa, I always talk to my clients about three things. You have to have three things. Number one, of course, you have to have extraordinary abilities. We have to hit the legal standard. Number two, you have to have a sponsor, either an employer or an agent. And number three, very, very important, you have to have jobs lined up in the United States. You have to have work. So for those individuals sponsored by an agent, usually they don't work in a traditional employment setting. They need to have a variety of jobs lined up for the period that we're going to request. So that is where the itinerary comes in, but it's not enough for them to say, well, here's what I plan to do. Here's the list of things I'm going to do in the US. They actually need to have, we call them deal memos in the entertainment context. You need to have deal memos or job offers, letters of interest, some type of employment offers to support the itinerary. So that's very important. Those don't have to be contracts, kind of set in stone for employment, but they do have to be realistic job offers.
What if it's like a comedian who has like 20 gigs set up, but while they're here, they get some more gigs? Do they have to notify USCIS of the extra gigs they got, or is it like I guess or a concert series? And they're like, oh, we got an extra date here, extra time here. Does that need to be updated, or does it fall within the general itinerary if it's like related to those what they're generally doing?
Yeah, so I think there is, that's a very good question that often comes up. So in the arts and entertainment context only, so O-1B, not O-1A. O-1A is science, technology, and so on. In the O-1B context, so comedian would fall under that. They are allowed to add new engagements to the itinerary without having to file an amended petition. In other contexts, an amended, if there's something new that comes up, material change, an amended petition is needed. But it's very common for entertainers to not know what else might come up
Yeah.
during the 3-year period. So it is a common thing. And usually when we file these cases, we include that in the agency agreement with the agent that they kind of reserve the right to add new engagements as they come up. So it is important to be able to do that.
It's important, I guess, to note that in there too, so you're covered to say, listen, we might be getting extra stuff. I always kind of add broader language to capture these kind of things.
Exactly.
Like
Yeah, we do the
when I do
same.
E2s, I'll like kind of because the people come here starting a business and then they got to kind of pivot or add more stuff. And then I'm like, okay, like if you try to think ahead of time at what you may add to your services and stuff to widen it up so it's all included to avoid having to do an amendment with USCIS because that could be a mess, having to repay all that and do all that over again.
Yeah, that's exactly it. And also, what's really important, some, for example, when I represent musicians, they're always like, "Oh, I think I'm gonna, I'm just gonna write music." And then halfway through the O-1 visa, they're like, "Oh, I also want to perform, and I'm going to be on TV. Is that okay to do?" Well, no, at this point, it's too late. We should have anticipated all of that at the beginning. So we usually have that conversation in the beginning. Let's think about what might happen in the next 3 years, because if you're going to be on TV, or maybe the shooting commercials or doing something like that, we need to add a consultation from an appropriate government
Yeah.
or a union. And all of that needs to be done up front. Otherwise, you need an amended petition and pay all the fees and do the whole song and dance again. So it is important to counsel clients and think proactively. What do you think you might be doing, even though
Mhm.
right now that's not the case yet?
How is the cost happening all this? Because one thing about O1s is I've never got into it, and sometimes people would come and say, "I'm using a paralegal, I'll only pay X amount of money." I'm like, I can't even like you can't even talk to me for that kind of money, and the expenses are going up. How does that all come into play? It's a lot of questions, and we can't really talk about a lot of them on the air like this. But has that have you seen costs become a factor in clients and their decisions with you?
Yes and no, because and that doesn't only come up in the O-1 context, it can come up in any context. There are always even lawyers, not paralegals, who will offer half the fee that I might charge. Whenever it's a substantial difference like that, something doesn't sound
Yeah.
right. Yeah, as a client, I would be concerned about that. If you're getting fees that are half of what you've been quoted by somebody who maybe you were referred to, I would be concerned. I always tell clients, I'm sure other lawyers use the same line. I don't think you'd want to go to the cheapest doctor, do you? You probably don't want to go to the cheapest lawyer. But and yes, certainly there, especially in the arts and entertainment, O-1P1 context, there are those paralegal shops that will do it for a lot cheaper. And then, of course, I've always seen many, many cases come across my desk where things were screwed up, and now we are fixing
Mhm.
the problem that was created by those kind of shops. So, as a client, I think it's important to have the right relationship with your lawyer and to choose correctly, and not
Yeah.
just think about the fee, but also, they know what they're paying
Yeah.
for.
In turn for us, our costs are going up, and just think when I quote fees now to people compared to what it was like 5 years ago. I remember I'm like, wow, essentially we're double the cost of what it was 5 years ago, and so it's like the inflation is really kicking in, and it's because my head I always think like I can't believe there's this much more. I feel bad sometimes when I quote a fee, but I'm like we can't do it for anything less. It's going to lose money. It's not even worth us doing it if we're going to charge that amount. And so it's like how do you, it really makes access to justice hard. The clientele we're talking about usually higher income ladder, but even then they're going to be squeamish about this stuff as it gets more expensive. Let alone the asylum and removal defense people who fees are going to be really high anyway, so the cases are complicated. Plus, many times they just don't have the wherewithal to do it. So, uh, have you been doing anything to make your processes more streamlined? Are you using AI or any other systems to try to like save attorney time on cases?
Yeah, so good question. Yes, we are. I am reluctant, and I'm kind of more old school, but I also feel like if we don't get on, the train with AI, we're going to be left behind in the dust. So I don't want to do that either. So we are trying to get into figure out how we can use AI, and there are specific AI tools for immigration, specifically for O-1, EB-1
Mm,
visas. So it is an interesting exercise. I can't say that we have been actively using it yet, because AI is just not at least what we've been trying to do is just not quite, the quality is not at the level that we like to produce for our clients. So, but I think it's going to get there.
yeah,
I don't think it's ever going to be like you just load up all the
yeah,
evidence and here is the petition and it's ready to go. It'll still need us to curate it, to supervise the evidence and the write up. I mean, we produce a pretty substantial support letter for these kind of cases, and obviously, there's legal analysis involved. But I do know it's coming and it's going to happen, and we all need to figure out how to use it, because also I think the fees are going to come down, and other
yeah.
lawyers who are proficient at it will be able to charge a lot less, and we're just not going to be competitive. So we need to figure out kind of that sweet spot.
And I guess one last question about this kind of stuff is how do you deal with the document collection for O's and EB1s? It's so intensive. And have you found a streamlined way to make it palatable, or do you force clients to properly label the documents, or just kind of give it to yourself or paralegal to go one by one and label them, for example, and organize them? How have you dealt with that mess?
Yeah, it's a mess. I agree. So we tend to collect them through kind of secure portal, either our case management program or like a Dropbox box, something like that. And then different clients are different. Some of our science clients tend to be kind of really more involved in labeling and giving us the docs. Sometimes they want to meet with us and discuss the documents. We don't necessarily need to do that. We know what they are, but the arts and entertainment clients, it's very hard to get
Yeah.
things out of them. Sometimes we are doing research online, to especially if it's somebody really accomplished, and that's all we're going to get from them. So we're just going to gather our own documents and prepare the case. So, and it's everything in between. It's just a very personal, but it is a very labor intensive process. I agree. And I don't think I haven't found a better way to do
No,
it. So we do spend time collecting, analyzing, figuring it out.
and that affects pricing too, because like you don't know ahead of time how well the client's going to deliver documents, and it's like insurance. Some insurance clients like use a lot of healthcare, and some don't as well. You kind of have to average it out, and it's sometimes unfair for a person who's really efficient, but we never know. I have cases like we do a lot of marriage green card cases. A client comes to me, I'm like they seem really on top of it, but it takes three times as much time to do it because they ask a lot of questions or they keep sending wrong documents. So you have to keep correcting them, this and that. And so we never know inevitably how long it's going to take. And we do flat rate. So it's like you trying to manage it, it becomes really hard. So it does just go out of control. And sometimes it does.
Exactly. We also do flat rate for 99% of our work. But I do know some of our colleagues do hourly fees. And of course, then you account for all the hours. But that also could mean that a case the fee could go out of control, and maybe they'll never hire you
Yeah.
again. So I mean, I prefer to do flat fees. And yes, you're right. It's one of these situations, you win some, you lose some, and hopefully it kind of averages out that, we earn some money on every case.
Yeah, for sure, for sure. Because I've been really cracking down on the hours on every team member put in, and every time you look, I'm like, we got to raise our fees because we're losing. It makes nominal money and it keeps going, but like it's in one sense we got to raise our fees. In another sense, just figure out ways to get much more efficient handling these. And that's why many years I stopped doing L's, for example, because it just take too much time to. The whole packet was a 1,000-page packet, and I've gotten back into them but because I have more staffing now. But just training and creating systems comes so important to try to keep the fees reasonable. So that's just I know you kind of feel for the clients because they're paying for this too. So I always be like, well, if I was in their situation, how would I want to think about it? But hopefully this technology does help, and that way it can just help more people in an efficient way.
Yeah, yeah, and it's a fine balance because, of course, we want to do a good job for our clients. We want to maximize our chances of success by putting in the work that you need to put in every case. But we do need to be conscious of being efficient.
Yeah, one thing that's happened since I've been like we increase our fees. It caused a lot less stress on me, particularly to make sure the numbers work for the office. And that lack of stress means I could spend more time studying the law, talking with clients, analyzing their case. Because I'm like, oh, I need another case here. I need to do some more marketing here to just like to get to hit the numbers we need for the month. And so for the clients, it may seem like higher fee, but actually really helps them get better service by doing that. So I always tell myself, I'm going to give better service because of the fee raise. It's not something that's it's just there to hurt people or just take the money from or something like that.
Yeah, yeah, that makes
Well,
sense.
very cool, Bria.
Makes
Thanks
sense
so
to
much
me.
for coming on the show. I know you got Best Lawyers Awards again consistently every year. So congrats on that and your firm
Sure.
as well. If people want to reach out to you, what's the
It's
best way they can do that?
email is the best way, either my website or my email, rsostrin@sostrin.com.
Great. We'll put that in the show notes as well. Stick in line for a second or two, but thanks again for coming on.
Thank you.
Thank you all for listening, and thank you, Rita, for coming on again. A lot of good information, a very good friend to have in the space. I got this podcast going again because I needed help on a J1 waiver situation that I'm not used to doing. Those J1s where someone is a doctor and they're doing it in a rural area that needs doctors. And I didn't understand how the waiver for that worked. And she was very kind and helped out on that because I never deal with that J1 issue before. So I was like, hey, wait, when talking, like, let's have you back on the show because you're a wealth of information. So I really appreciate you coming on. If y'all interested in being on the show, we got a lot of people reaching out. Ideally, we try to get you something, particularly in the magazine, because we always need more authorship. 2 or 3 page article will be helpful. Email me with your topic, info@immigrationlawyerstoolbox.com, and we'll see what it is. We'll flesh it out, get an article in, then we'll talk about it so people get to know you and your work as well, and help support your firm and support the community by sharing that information. I had some deep thing I wanted to talk about, but as soon as I started, I forgot what it was. So I guess with that, I'll leave it. Enjoy your weekend. I mean, by the time this comes out, weekends will be over. But thanks so much for listening. I'll see you all next time. Bye bye. If you like this episode, follow us on Instagram. Our handle is Immigration Lawyers Toolbox, where we post the latest statistics, tips, and more. And stay tuned for more from the Immigration Lawyers Toolbox podcast.